SJC-11926, Michael Skawski and others v. Greenfield Investors Property Development, LLC, and another.
Good morning, Mr. Lesser.
Good morning, Your Honors. May it please the court, I plan to begin by taking a minute or two to go over the factual genesis of the case, then go on to discuss how the case came to you procedurally, then talk about the legislative history and the law concerning the enactment of the land court permit session, and finish with what is at stake for my clients.
You may do that, but I think you can presume that we've all read the briefs, so I'll leave it to
Maybe
you,
get one.
but you may want to move to the legislative history a bit more quickly.
I do want to spend some time on the legislative history because I think it's misstated, actually, in Greenfield Investors' brief, dramatically misstated, and certain points are lost there. So that's one thing I do want to go over. To begin, Your Honor, as you know, my clients own houses directly across from vacant land on the outskirts of Greenfield. A 135,000-foot retail structure was proposed for that land. To give you the size, some sense of the scope, that's the size of a large Walmart. A special permit was required. The special permit was granted by the Greenfield Planning Board, and a decision issued. And that decision said that if, in fact, you have a right as an interested party, and my clients are abutters, so they do have that right, you have the right to appeal within 20 days under General Laws, Chapter 40A, Section 17. And 40A-17 gives you the option of going to one of four courts. And one of those courts is the housing court. And that's what my clients did. They filed one day 16 in the housing court. It's the local court with the most expertise about land issues. The land court, of course, has expertise.
Most expertise about land issues?
About
housing
property
court?
issues, property rights.
Okay.
Property rights. The land court obviously has expertise also, but the land court has never sat in Western Massachusetts as a practical matter, although by statute it's allowed to.
Yeah, but
So they apply, yeah. You have a question, Judge Gordon?
so you're saying, well, the housing court judge will know the place, so therefore that's appropriate as opposed to having expertise about permitting and major projects and
They deal with special permits all the time. You know, I've been before the housing court probably on 10 different special permit appeals on both sides.
and this is sort of also the grist of the mill of the land court.
It is the grist of the mill of both courts, Your Honor.
The housing court, it's the grist of the mill of the housing court.
Yes, they do that. They do that a tremendous amount
On major projects.
on all sorts of projects,
Okay.
major or not major. And we file, and there is no jurisdictional issue raised initially. We file in 2011. The defendant, Greenfield Investors, moved the Chief Justice to transfer it to the land court, but not on jurisdictional grounds, on administration of justice grounds.
And they didn't raise the 2006 special permit, this whole legislation?
They didn't raise any jurisdictional issues regarding that. They simply said the land court would be better situated to hear the case, therefore the administration of justice would be facilitated by transfer it to land court. No jurisdictional issue was raised at that point in time.
When was the first time a jurisdictional issue was raised?
I'm sorry?
When was a jurisdictional issue raised?
It was raised after discovery, after a motion for summary judgment on standing was denied, and 9 days later, a jurisdictional issue was raised.
Of course, it can be raised the first time on appeal, can't it?
I'm sorry?
Jurisdictional issues can be raised at any time,
Absolutely.
even on appeal for the first time.
Absolutely. well into the litigation when it was first raised, that's all I'm saying.
Well, that was motivated by the decision in the Buccaneer case, though, wasn't it?
Well, that seems to have been motivated by the decision in the Buccaneer case. They're holding us to have known that the Buccaneer case was going to come down, all I'm
Well,
saying.
no, they're saying that this is the law now, so this case can't be here in the housing court.
Right, and we're saying that it can be in the housing court. That's the nub of our disagreement.
Okay, well, can you explain that to us? Because that's what we're all waiting to hear.
Okay. We have a statute, 40A-17. It says there's exclusive jurisdiction in 4 courts. 30 years later, in 2006, 3A has passed, General Laws Chapter 3A. And that says there's original jurisdiction in 2 courts, and it sets up a permit session in the land court for particular types of large developments. Now, I think it's but there's language in there, and I particularly call your attention to the transfer language. And the transfer language states that if an action is not commenced in the permit session, but within the jurisdiction of the permit session, it may be transferred to the permit session upon motion of any party, by any party to the Chief Justice. Doesn't say it shall be transferred. Doesn't say it's automatically transferred. It says it may be transferred upon motion. It could have easily.
So the statute gives original jurisdiction to the Superior Court and the Land Court, and then says if it's not filed in the permit section of the Land Court, it can be transferred there upon motion. Isn't it logical to read, if it's filed in the Superior Court, which is the other court that has jurisdiction, it can be transferred to the permit session of the Land Court?
Well, I think that has to do with whether or not you think 17 is still in effect and still an option. But you go to the legislative history, and the legislative history is quite interesting. The bill originally is introduced, states that there's going to be a permit session in the Superior Court. And it says that if a case is filed in the permit session in the Superior Court, upon motion, it shall be transferred. So it says, number one, it doesn't mention the land court at all. The first iteration of the bill doesn't mention the land court, it's Superior Court. So according to the first iteration of the bill, you could file it in the land court or you could file it in the housing court, and if no one makes a motion, it stays there. There's a second iteration of the bill, and the second iteration of the bill is suddenly we have the land court. But in the second iteration of the bill, on the second reading, again it says, upon motion of a party, it shall be transferred to the permit session of the land court. It's still mandatory that it be transferred in the second iteration of the bill. All we know that happens after that is Judge Creedon says, that's placing too much of a burden on the land court. I'm concerned about the resources. Senator Creedon, if I didn't say that. And we know that it goes to conference, and we know that it comes down with this watered-down version, which is the case may, upon a motion, be transferred to the permit session. It's no longer mandatory.
But doesn't the legislation go on to say, but if there's a jury demand, it has to go to back to the Superior Court?
Of course, but it could have.
Okay, so, I mean, we're talking about the Superior Court and the Land Court here, aren't we?
Well,
If a jury demand is made, it has to go to the Superior Court.
they could have said it has exclusive jurisdiction, or they could have said it shall be transferred automatically without motion, omitting the words upon motion. It shall be transferred anything that's not in the permit session shall be transferred automatically to the permit session, except for jury cases, which shall be held in Superior Court. They certainly knew about the word shall. They used it in all their...
But the Superior Court could hear this case, could it not?
Well, I think the Superior Court could hear this case. I think that the Housing Court could hear this
Well,
case.
under 3A, the Superior Court could hear this case.
That's my understanding, although the Greenfield Investors has suggested, seemingly suggested, that that's only for jury cases. That's why they think that jury language was thrown in there, and that's why they claim that shall became may.
Well,
you
no,
said-
isn't it that they can hear it, but if there's a jury claim, they must hear it?
Correct.
Well,
That's my position.
You said it was 2006 for 3A? It was not 2012?
no.
No, I believe it was 2006.
2006, okay.
2006.
It says effective 2012 on the
It
AD09.
affected the Buccaneer decision in 2012, and at end of 2012.
Okay, so now, was there not, though, a legislative, I mean, what was the reason to create a special session of the land court? Wasn't the theory is that development was being stalled and we wanted a prompt judicial adjudication of these matters, which of course has been thwarted in this case? What about the whole legislative intent to get these things resolved quickly and professionally?
Well, there is no legislative history, it's fair to say. They say that's the opening of their legislative history paragraph. It's conclusively proved. There was one guy, Representative Rodriguez, who stood up at second hearing, according to a commercial newspaper, and said that.
Well, there is legislative history because you've just been talking about it, and it's gone here, it's gone.
I meant that is not legislative history, what Representative Rodriguez said. I think the legislative history is looking at the iterations of the bill. It started out as a Superior Court
So
permit
let's
bill.
frame it differently. What do you say was the legislative intent to go to pass this bill?
To provide another forum if the Chief Justice felt it was an appropriate case to go to the permit session. That's why they said upon motion, it may go to the permit session. But the permit session might not have the resources to be handling it that case in time. That's a Chief Justice issue. It's not a shall. It could have been a shall. The defendants argue that it's a shall, essentially.
Does the record reflect how long it would take the housing court to determine one of these bigger development cases?
I don't have anything in the record. The housing court said we're going to set up an expedited schedule. At the time they brought their motion to dismiss, we already had trial dates.
How long did the whole case take?
The whole case took about a year and a half. They did 7 depositions. That slowed the case down. They did a motion for summary judgment on standing. That slowed the case down. Once that was decided, the housing court judge did exactly what you have instructed housing court judges to do in Arno and Constantopoulos, most recently in Caton. The judge applied to be designated a Superior Court judge and to be able to hear this case. First, she asked for it to go to the Superior Court, and then she said, I'd like to be designated. The chief judge of the housing court did not act on that. It was only if it was after it was unacted upon for 6 months that finally she issued her decision finding that she had jurisdiction.
Now, what do
And we have later filed a motion, which has been pending for the last 10 months with the Chief Justice, asking the Chief Justice.
Chief Justice of which Chief Justice?
Chief Justice of the trial court.
Of the trial court.
Trial court, Judge Carey, to transfer this case, and we have the right to make that request. We did make that request, to transfer this case to the Superior Court or to the Land Court to try to forestall this issue. And the judge, again, the Chief Judge has not acted on that.
Well, did you make the motion after the appeal mechanisms were started? I mean, it may be that since the case is pending here, I don't know. Is that possible?
It is possible. Certainly, I think it was after the appeal mechanisms began. And one thing we're asking, if the court should find us against us and find that the housing court does not have jurisdiction, that the court stay that order with instructions for Judge Caton to transfer it to one of those two
Is it the
courts.
defendant's position to argued below that the housing court, because it never had jurisdiction, you've just filed in the wrong place and you're out of luck?
That is their position, but certainly in Caton, you have the authority, even if there's no jurisdiction in the underlying court, to transfer it to another court, or the Chief Judge of the trial court does.
So if you file in a court, for example, if for some reason somebody filed it in the probate and family court,
I'm sorry?
if for some reason this was filed in the probate and family court, which does not have, under any statutory scheme arguable jurisdiction. Is it still possible to transfer it?
I think this court can transfer it. Whether the chief judge or the trial court can transfer it, I haven't researched that issue. I'm not sure.
If you say the legislative history was simply to create this permit session where, you know, it could go if the Chief Justice thought it would be an appropriate place, why does the legislation give original jurisdiction concurrently to the Superior Court and the permit session? Why not just say we've created a permit session and stuff can be transferred?
I think if you look at the iterations of the bill, that was a holdover. The original bill was Superior Court, concurrent jurisdiction in the Superior Court. A permit session, a special permit session with judges from any courts as part of the Superior Court. Then it said concurrent with the Superior Court. And then when it went to the land court permit session, that language was retained concurrent with the Superior Court, and it continued throughout the proceedings.
What do we do with Chapter 185C, Section 20, that any civil action within the jurisdiction of a housing court that is pending in another court department may be transferred to the housing court by any party? Is there a conflict, if you're right?
I'm sorry, Judge, I didn't follow that.
185C, Section 20 says that any civil action within the jurisdiction of the housing court that's pending in another court may be transferred to the housing court by any party. So if that's the case, then you're saying that whenever there is a permit, it can be transferred to the housing court by any party.
Even if it's filed in the permit session of the land court?
I think the permit session says it can't be transferred out of the permit session. There's specific express language that cannot be transferred out of the permit session. And I think that section is only applicable to certain kinds of cases, but I don't have it in front of me, Judge.
Okay.
But we are talking only about cases involving major projects here.
Correct, of course.
Does the housing court have original jurisdiction over 40A appeals?
Yes.
Yes, yes. The housing court is one of the 4 courts under Section 17, 40A, Section 17, that has, quote, exclusive jurisdiction. It's Superior Court, Land Court, Housing Court, and District Court. 3A doesn't talk about exclusive jurisdiction. It could have said that the permit and Superior Court have exclusive jurisdiction over these cases. It didn't. It just said original jurisdiction. And we suggest that it's concurrent jurisdiction and that we have these projects and they're available to go to the permit session upon motion of a party, or they could be filed originally in the permit session.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Marshall Centerfit for defending Greenfield Investors Property Development. Chapter 40A-17 does not grant exclusive jurisdiction to any court. The only existence of the word exclusive in Chapter 40A-17 refers to the remedy that's provided there, which is the purpose of which is to say that Chapter 40A-17 is the only mechanism under which an aggrieved party may challenge a permit. Chapter 40A-17 provides a list of courts, it's correct, that have jurisdiction that an aggrieved party may bring a challenge under for a permit decision.
What's the distinction that you're drawing? I don't understand.
The distinction, Your Honor, is that my brother has said that Chapter 40A-17 states that jurisdiction is exclusive in the courts listed therein. It doesn't. Chapter 40A-17 says an aggrieved party may bring a challenge to a zoning decision in one of 4 courts.
So you couldn't do it in probate court?
Right.
You could not.
So doesn't that
Mean it's got exclusive?
Doesn't that mean it's exclusive in the other courts?
It does, Your Honor, in the same way that Chapter 185-3A also means that jurisdiction is exclusive in the Superior Court and in the permit session of the Land Court. The point being that the term exclusive does appear in 48. It's not a reference to jurisdiction, it's a reference to remedy.
But are there, I mean, isn't it the case that there may be, I don't know what they might be, but aren't there statutes that talk about, X court or X courts have exclusive original jurisdiction, that they actually uses the word exclusive and this one doesn't?
There are, Your Honor, and interestingly, in our research, we are unable to find a single example in which the legislature has used the word exclusive to refer or to confer jurisdiction on multiple courts. Wherever jurisdictional statutes that we've been able to identify provide jurisdiction to more than one court, they use the terms concurrent and original. Sometimes they provide a list of courts. And very importantly, in the thrust of our argument as to the statutory interpretation here, is that the tenets of interpretation well established by this court expressly find that the omission, the statutory omission, operates as an intentional exclusion by the legislature. As a question...
Well, either that or it established a peculiar relationship between the Superior Court and the Land Court. Chapter 185C, Section 3, talks about the jurisdiction of the Housing Court. Does it talk about, and it mentions Chapter 40A, does it talk about exclusive jurisdiction or original jurisdiction?
Chapter 185C, Section 3 talks about the jurisdiction generally of the Housing Court. It doesn't talk about exclusive jurisdiction of the Housing Court certainly over 40A. And interestingly, in this court's decision in Bagley, the Illyrian Gardens, a very similar situation. In that case, this court considered the relationship between 185C Section 3 and 40A 17. In that decision, the court recognized that standing alone, 185C3 appeared to give the Worcester Division of the Housing Court jurisdiction to hear a challenge of a comprehensive permit. However, this court found that that statute must be read in connection with 40A 17. At that time, 40A 17 provided jurisdiction only to the Superior Courts and concurrent and to the Hampden County Division of the Housing Court. The holding in Bagley was that because 40A 17 omitted from its conference of jurisdiction the Worcester Housing Division, that the Worcester Housing Division did not have jurisdiction in that case. The same result should apply here, where the legislature has omitted the Housing Court from its grant of jurisdiction. It is deemed to have done so intentionally. And again, it's a simple carve-out. It doesn't eviscerate the jurisdiction under 40A 17. It only modifies 40A 17 such that for large-scale developments that meet the jurisdictional parameters in 185 Section 3A, just those cases are no longer subject to the jurisdiction of the Housing Court.
So when the statute talks about if a case that qualifies is filed in another court, the Chief Justice of the trial court may, upon motion, transfer it. But I take it, number one, if nobody makes a motion, it stays in wherever it is, correct?
Correct, Your Honor. Our position being the only place that it can be the only other place it can be is the Superior Court, absent some unique circumstance.
I was wondering whether there's anything in the history to suggest that was that language there as a kind of transition?
Your Honor, in fact, I'd like to mention the legislative history. I think it's abundantly clear that this statute 185-3A was part of a far-reaching attempt by the legislature to overhaul the system then in existence because it was deemed to be threatening to the economic health of the Commonwealth. And the evolution of the statute did, in fact, start with the idea of a permit session in the Superior Court. It was then determined that Superior Court judges would have a difficult time elevating permit cases over other serious matters, criminal matters. It also was recognized that they may not be the judiciary with the most expertise and experience to hear, in particular, large-scale development. as my brother has alluded to, an earlier version of the statute, once it was the permit session of the land court, stated that upon any motion, the matter shall be transferred to the permit session. In that draft, there was no reference to a jury trial. It seems very clear to us, because the reference to the jury trial is added in the same amendment as the transition from shall to may, that the legislature was simply attempting not to create a contradiction where it said, any case, upon a motion by any party, a case shall be transferred to the permit session. Then you're left with, what about a case that has a jury claim? What do we do? There can't be a jury trial in the permit session. So it was simply an accommodation to recognize that these permit cases oftentimes can include other counts, other claims that might raise a jury.
But a
issue.
housing court can have a jury,
The housing court can have a jury under certain circumstances,
But the
correct.
land court can't.
the land court can't.
The land court can't.
Let me ask you the same question I asked your brother, because I don't understand your position on this. Are you saying if it was filed in housing court, because housing court did not have jurisdiction ever over this kind of a question, that there is no possibility of it having been transferred from housing court to land court?
In fact, Your Honor, that is the result that we think has to happen. The fact
If
of
you
the
make a
matter,
mistake and you file it in housing court under section, under the ordinary permit rules, you're saying you're just out of luck because the court never had jurisdiction and you just can't transfer it at all to either Superior Court or land court?
yes, Your Honor, that is the effect.
Even when the decision says you have a right to appeal under 40A-17?
In fact, the appeal is pursuant to 40A-17. What we have now is a regime in which 40A-17 remains the exclusive remedy to challenge a permit issued in the Commonwealth. Chapter 185, Section 3A has modified 40A-17. They must be read together, like this court has done in Bagley, like this court has done in other circumstances, such that now a 40A Section 17 appeal for a large-scale development may only be filed originally in the Superior Court or in the permit session of the land court. In this court's decision in the matter of Commonwealth v. Russ R., also cited in our brief, this court dealt with the relationship between two statutes concerning the authority of juvenile courts. Chapter 119, Section 56D grants a juvenile court judge all of the powers of a Superior Court judge. Subsequently, the legislature enacted a statute, Chapter 233, Section 20E, conferring upon the Superior Court, the Appeals Court, in addition to this court, the right to immunize witnesses. The issue the court faced in Commonwealth v. Russ R. was, did the prior statute saying that the juvenile court judge has all the powers of the Superior Court mean now, after the passage of the immunity statute, that the juvenile court judge had the authority to immunize witnesses? This court held, in fact, it did not, that the legislature, having omitted the juvenile court from the subsequent more specific statute, giving power to immunize witnesses, had done so intentionally. Further, this court recognized in that case the Commonwealth's argument that was, but wait, if you do that, Your Honors, if that's the interpretation, Chapter 119.56D no longer means that a juvenile court judge has all of the powers of the Superior Court. It means it has all of the powers except this new immunity power. And this court said, that's correct. Chapter 119.56D no longer means all of the powers. And that is a consequence intended by the legislature, and we live with that
how can it
consequence.
possibly be fair that a plaintiff who brings a appeal timely to the place that the permit authority says they should bring it loses their ability to have it decided on the merits?
Particularly when you don't raise it for a good number of years until after the Buccaneer decision.
The permit at issue does say that the decision could be challenged pursuant to 40A-17. It can be challenged pursuant to 40A-17. As of 2006, effective upon the passage of the permit session statute, only for cases exceeding a certain size, square footage, or
Right,
housing
no, I understand the
units.
argument. The question is, how can it be fair to obtain the result that you seek, which is that they are denied any opportunity to have this matter heard on the merits by a court with jurisdiction, even if you're right?
Your Honor, the reason is that the legislature passed a law in 2006 making that rule.
Didn't you seek transfer to the land court?
We
So you didn't understand that either.
We did seek transfer to the land court, Your Honor, and it is correct that we hadn't analyzed the jurisdictional issue at that point.
So you're saying if it had been transferred to land court, you would still have the opportunity at this juncture to say that the land court doesn't have jurisdiction because the transfer to it was from a court that didn't have jurisdiction.
Had that transfer gone through and we prevailed at trial, the plaintiffs might have appealed and may well have succeeded on the fact that that transfer was improper. Now, on their same argument, they would have missed the 20-day statute of limitations, and I would point out in response to this that any ability for a plaintiff to file in the wrong court and then subsequently transfer to a new court would effectively extend the statute of limitations, which is 20 days, to a very long period. In this case, it would be 4 years. If this case comes out ruling that the plaintiffs have such an opportunity, then in the future, plaintiffs challenging permits or permitting decision could simply file in the wrong court, knowing that they would subsequently have an opportunity to find the right court, thereby extending the time.
We're dealing with a statute which you say eliminated Section 48, Chapter 48, Section 17 jurisdiction to the extent that it encompasses appeals of 25 or more dwelling units or construction of 25,000 square feet, but didn't say that. I mean, the legislature, the bill you're proposing could have said, to the extent that that Chapter 48, Section 17 gives jurisdiction to all cases, we narrow the scope of that jurisdiction only to cases but exclude these.
It could have said that,
And
Your
you're saying
Honor.
we should read it to say that, but are we expecting every person challenging an appeal to understand that within 20 days of the permit decision?
Especially when you didn't?
We are now. It is incumbent upon all of us as attorneys to understand that future law impacts prior law. The statute I referenced in Commonwealth v. Russ, for example, still states that the juvenile court has all of the powers. A lawyer practicing in the juvenile court has to now know they cannot ask for the immunity of a witness in the juvenile court because of this court's subsequent decision. The legislature does not always go back. It does not always say that. And what I would say is that this court's decisions have repeatedly held that where you have an omission, like we do here of a particular court, the effect is in fact an intentional exclusion. And
Isn't this, I mean, this strikes me as a little different. I mean, the housing court still has jurisdiction over the appeals of permits. It's just not this, so if it's just below this size, they have jurisdiction. Just above, you say they don't have jurisdiction.
yes,
So isn't this really different? I mean, it's the same beast, just the size has just grown a little bit.
it is a carve out of a prior statute, which has happened in this case, and it's happened before.
Before
under
you
this
sit down,
decision.
I just want to ask you, what does this mean in Section 3A, where the statute says, any action not commenced in the permit session, but within the jurisdiction of the permit session may be transferred to the permit session upon motion by any party to the Chief Justice. So doesn't that cover the situation that we're talking about right now, where you say there's no way that it can be transferred to the right session, to the permit session?
Our reading and the argument we advance in our brief, Your Honor, is that that means that a case filed in the Superior Court may be transferred to the permit session. Also, there could be a scenario in which...
No, wait. Any action not commenced in the permit session. So that means the housing court, right?
No, Your Honor. That means the Superior Court. The statute, you have to, reading the entirety of the statute, it confers jurisdiction on two courts.
Trust me, I have, but I don't understand how you reading Superior Court into this language that says any action not commenced in the permit session.
So that is any action not commenced in the permit session. We say that in the context of the statute, it means the Superior Court. I would note, however, it could mean, for example,
Court is a designated permit session, so how could that be?
because if the case is filed in the Superior Court, but within the jurisdiction of the permit session statute, so in other words, if it's filed in the Superior Court but exceeds 25,000 square feet or 25 housing units, upon motion, it may be transferred from the Superior Court to the permit session.
But the permit section has original jurisdiction concurrently with the Superior Court Department.
It does, and so the purpose of that provision that Justice Hines was just referencing is essentially to help achieve the legislative intent here, which was to concentrate the cases into the permit session wherever possible, and so to provide the Chief Judge with a mechanism to facilitate that legislative intent by taking cases that, although filed in a court with original jurisdiction, the Superior Court, although it has jurisdiction, to still provide a mechanism after filing to move that case to the permit session. And as we discuss in our brief, the reason for that, again, is the clear legislative intent to concentrate cases in all possible scenarios dealing with large-scale development, that was the very purpose of this statute, into the permit session of the land court.
But how then do you, subsequently, there's a sentence that says there shall be a presumption against more than one transfer of a case between any departments of the trial court. How do you make sense of that?
That, Your Honor, recognizes the potential that cases are fluid and they change. For example, a case could be filed in the permit session and there could be a jury claim asserted, a counterclaim, for example.
Any departments of the trial
Doesn't
court.
say the Superior Court Department.
Also recognizing that, for example, a permit session case could be filed in the permit session, meeting the jurisdictional threshold, and there are additional claims. Something could change in the case. For example, it could be that a portion of the permit challenge is dismissed right away or is released by a party, thereby adding jurisdictional options to a case, or different claims. It's not uncommon that these claims will have ancillary claims. They could be contract claims, they could be jury claims, they could be constitutional claims. And so what that provision of the statute recognizes is that as a case changes, the legislature is saying that we have this goal here. We want these permit cases in the permit session of the land court. We've provided mechanisms. That's the purpose of this statute. We don't, however, want cases flip-flopping back and forth between courts as they evolve and either add jury claims, drop jury claims. We still do want a case to proceed. And our argument, again, in our brief, is that this statute simply reflects the fluidity and the ability of a case to change, and the fact that something may happen where you no longer are limited by the jurisdiction or where a jury claim comes or goes.
If I could return to Justice Cordy's question. The permit is challenged with the understanding that the construction is going to be of 24,900 feet. Person loses the appeal, brings it to the housing court as they're allowed to, correct?
Correct.
Turns out that's wrong. It's actually 25,010 feet. You then move to say the court has no jurisdiction. 20 days have passed. You've lost your ability to challenge it in the merits. That's your position?
That would be the position, Your Honor. Depending on the reason for the error, the party making the error, again, I think it's important to recognize the 20-day statute of limitations. And the point that Your Honor raised earlier about 185C Section 20, which would say effectively if the housing court has jurisdiction, any case filed in the permit session or the Superior Court, any time, could simply be transferred to the housing court upon motion. That would eviscerate the purpose of 185.3a to concentrate cases concerning large-scale permitting and developing in the permit session of the land court, because any plaintiff ever challenging a successful permit application could simply move the case to the housing court, which doesn't have the same expedited track, doesn't have the same collection of expertise and experience in its judiciary. And really you would have a statute, its whole purpose is maybe you can have a permit session Maybe you can bring your large-scale development in the permit session, but only if nobody moves it to the housing court.
Okay, thank you.
Thank you, Your Honors.